My name's Andrew Dongworth. I'm a Senior Associate Solicitor for HRJ Foreman Laws, and we are all service solicitors based in Hitchin, Welwyn Garden City and Letchworth. I work in the company commercial department based in our Welwyn Garden City office, and I provide a range of services to businesses, whether that be contract law, company law, commercial contracts or commercial property work. We work to help businesses achieve their goals, to grow and to avoid any potential issues or pitfalls along the way. In essence, a shareholders agreement is a document that's put together between the different shareholders in a limited company. So a shareholders agreement will firstly contain provisions about who's going to be the directors of the company, any decisions that need to be taken by unanimity of the shareholders rather than by a simple majority. And it will also potentially deal with things like dividend policies if it's going to be more complex than just a simple director's decision on what dividends to declare. If there's a certain calculation or formula that's been agreed between the shareholders, then that can be set out in the shareholders agreement. I sometimes feel when I'm talking to clients that I'm sounding like a harbinger of doom, but you have to think about the worst case scenarios that might happen in life. So the business relationship breaks down between the shareholders. It may be that somebody, a third party, comes in and wants to buy the entire shareholding of the company, and perhaps one minority shareholder, maybe it doesn't really want to sell or doesn't believe that the price is correct. You can include in the shareholders agreement provisions that allow the majority of shareholders to require the minority shareholder to also sell their shares so that it doesn't scupper the deal. I think the key thing to think about if you're in a situation with other shareholders in your company is how are we going to deal with these issues if they arise? Are we all on the same page with that? And if we are, let's get this agreed as a framework now rather than waiting for potentially a few years down the line and something happens out of the woodwork, unexpected, or potentially our relationship breaks down for whatever reason, and then we can't agree on how to deal with things in the future. So something that I often discuss with business owners or existing clients is the question of whether their business is up to date with its various policies, documents and contracts. You know, again, you can find most legal documents online these days, but they're only going to be generic templates. They're not going to be bespoke to your business. I've even seen people that have brought to me terms and conditions of business that aren't even governed by English law. You know, they found them online and they maybe are from America or Australia. Part of what we offer as a service is that we like to understand our clients' businesses. We like to make sure that the work that we do for them produces documents that are specific and bespoke to their business rather than just a generic cut and paste document. So there are probably three other areas that clients can think about. First of those is to make sure that your terms and conditions of sale are properly structured and cover any particular bespoke issues that may be particular to your business. So obviously that's the contractual relationship between you and your customers, whether you're providing them with goods or services. It sets out how things are going to operate, but it's also important to include things, for example, such as a limitation of liability clause so that you can make sure that you can keep a lid on any potential liabilities for issues that may arise in the future. The second area is in relation to your employment. Some companies either have in place very old employment contracts with their employees that haven't been updated for many years, or may choose to start off without any formal contract in place. Fundamentally, it is required by the law, but also it will help you in a situation where maybe there's an employee issue and you need to refer back to that contract in the future. Likewise, employment handbooks, policies and procedures are also very important, whether they relate to disciplinary policies, grievance policies, or simply privacy and data protection policies, to make sure that there's a good framework in place for knowing how your employees are going to operate while they're working for you. Third area is if you're a company that has commercial premises, you need to obviously be fully aware of the contents of your lease, in particular break dates, rent review dates and eventual termination dates of the lease. So you know, for example, that if you need to serve notice to break the lease at a certain date, if you choose to do that, you don't miss the date and miss your opportunity. Likewise, if you're coming up to a renewal, you need to know whether you've got the right to renew under the Landlord and Tenant Act or whether it's simply a case that the landlord could ask you to leave at the end of the lease term. Forearmed is forewarned when it comes to things like that. You need to know so you can plan for your business over the next year, 2 years, 3 years, and if things are going to change, you can plan for them accordingly.